So a question that I get a lot is, I had a will created in another state. Is it valid in Alabama? So the law in Alabama is, if that will was validly created in that other state, then it's valid in Alabama. But the way that I describe it sometimes is validity is kind of a low bar. So even though that will may be valid, there may be some other things that we want to think about in terms of, should we go ahead and make another will in Alabama? So validity is kind of a low bar. So we definitely want it to be valid, but we want it to do some things beyond that. So we want it to do some things that are going to make the estate process easier in Alabama. And each state has their own differences when it comes to the estate process. So a will created in another state may not have those things that we would want in there to make the estate process easier in Alabama. So for example, it may not waive the requirement of a bond. It may not be self-proving, so we don't have to track the witnesses down. It may not give the right to be able to sell real estate without having to go back to probate court again and ask for permission from the judge. So we want to make sure, ideally, we want the will to have all those things to make the probate process easier. So the other thing is, a lot of times when I talk to people and they've created a will in another state and now they moved here in Alabama, is maybe just the passage of time. So a lot of time may have gone by since they originally created that will. And sometimes when they go back to it, they find, well, maybe some things have changed. And so maybe even though my will is valid in the state of Alabama, maybe it's time to just go back and change some things anyways. And so we would want to just make a will in that situation.